Okay, the centerpiece of what we're doing is labeled free speech, free exercise, and free assembly, and I'm not going to run through slides. We're going to do this together with a handout, and you should all have that, and if you don't, it's on the table outside. Get one. And we're going to run, okay, just like I did the free report. Now, why am I taking that position? Because essentially what we thought we would put together is a little bit of a primer on handbooks, because all of these rights about which we will speak are of not much substance until you incorporate them into your society, and you incorporate them into your society with a handbook. Now, here's a key cheater point on handbooks. Don't start one of these things from scratch. Do yourself a favor. Thank you. I'm very much geared towards the problems of small colleges and universities, because when I was in outside practice, my practice was geared to assisting small colleges and universities. And what that means is they have no money, essentially, and they have no lawyer, and they have no contract specialist, and they have no media specialist. They have none of that. So what we do is we learn how to economize, and the way you economize is you cheat. The first thing you do when you need to write a new handbook is you get on the internet, and when I started my practice, there was no such thing. You get on the internet and you punch in student handbook, and then you hyphenate and you go free speech, or you go student media, or you go put your favorite phrase in. And the next thing you will get in front of you is 6 examples of where to find student handbooks on that subject. Do yourself a favor. Go to those websites, read it. If you like it, copy it. Sometimes I call for permission. No one will ever say no. Sometimes I call for permission. Sometimes people don't post a copyright on their material because they want you to copy it. If you're public, do that anyway. The big public systems have researched these issues to the nines. You don't need to reinvent this wheel. Just take someone else's and run with it. The small privates look to places like RPI, look to places like MIT in the technical world, look to places like Harvard. It's a not-for-profit, and they have a student handbook. And they may or may not do it well, by the way, but give it a shot and see what you come up with. So that's it. Next thing, there are books, wonderful texts. Bob Bickel and Peter Lake have authored at least 3 different books. The Rights and Responsibilities of the Modern University, I'll leave this here because the ISBN is on it. Peter Lake's new one is co-authored, it was published by NASPA, The Foundations of Higher Education Law and Policy. His prior one is called Beyond Discipline. They have all the guidance you could possibly want on these subjects. The ASCA, which when we started it was ASJA, published a collection of articles edited by Brent Patterson, and I've forgotten the name of it, but we have it at the table. It has an article on every subject you would want. Get that article and do it. And finally, outside, the Education Law Association has a table. They used to be thought of as K through 12. They're beyond that. They cover higher ed. I borrowed their 2 books last night, and I did it with permission. I was very proud of myself. I borrowed their 2 books last night just to read the free speech part. They're excellent. They have an excellent discussion in this one on faculty issues, and then they have student issues, and they go all the way to student publications. And then this is something they call a yearbook. So what happened in the last year, and they divide it by the same table of contents that they do this book. And it works. You can come to something quickly, and the index is good so that if you want to look at a particular case, you can do that also. So much for the commercials, okay? A little bit of substance. I'll give you as little substance as I can. The first thing I want to mention to you is we're using technical terms in this meeting, and you have to adapt yourself to that. And it comes from the way the American legal system is set up. And for those of you who came to the opening session, Steve is in the back of the room with us. They did this wonderful piece, and we have it in hard copy. Please take 12 copies home. They did this wonderful piece about how the American legal system is set up. And the shortcut to that is we operate under something called a Constitution. The Declaration of Independence is a declaration of intent. The Constitution is the basic law of the land. There is a federal constitution. Each state has a state constitution. Under each of those documents, there are statutes. The federal statutes are divided by numbers, and then within each number classification, the feds divide their statutes by titles. So when someone says to you, Title I, you want to really ask, Title I of what? Because all they're saying is Chapter 1, all right? We say Title IX. Title IX is a specific Title IX of something, and I've given you the full citation in the paper. The state statutes are divided by sections. And then you have, now our legislatures change those things through a laborious process. We got into lazy legislation back in the 60s, and we developed a very expansive system of executive government, both at the federal level and the state level. And out of that came something called agencies. You all hear of the agencies. The agencies publish something called rules and regulations. Now, on top of all, and by the way, to really understand what the law is on a given subject, you go from the Constitution to the statute to the agency rule and regulation, and if you're really good and you're doing it on the federal level, you go to the Federal Register to see what change in the agency regulation is coming down the line, because that's how they publish them. All right, but the overlay to all of that in our constitutional system, with the possible exception of Louisiana, nobody really knows how Louisiana works except people who live there. But with the possible exception of Louisiana, we have a common law phenomenon, which means judges get to interpret every one of the words in every one of the foregoing documents, foregoing being a legal technical term. So the Constitution, the statutes, the rules, the regulations are all subject to judicial interpretation. Guess how many days a week and guess how many weeks a year the state courts meet? And guess how many days a week and guess how many weeks a year the federal courts meet? And the nuts of that is this simple proposition. On any given moment, in any given day, if you say, what is the law on free speech, there is no answer without sitting down at your trusty computer and punching in, how does free speech stand today in Arizona? How does free speech stand today maybe in Tucson, Arizona? That's how difficult this all gets. So that's the overview. And what I've done for you today is taken the philosophy of this and laid it out so that you understand the basic rules about creating handbooks. The first thing you have to understand is, for purposes of colleges and universities, we divide the world into public and non-public. The non-public is called private not-for-profit and also private for-profit. The reason we do that is because the Constitution of the United States says the philosophy of the document is set up like this. All of the power in our government belongs to the people who are its citizens, except the following. Now, in the exceptions, part of it goes to the states. And the founders thought they would take a very small part of it and give it to something that was an embryonic central government. That embryonic central government, of course, has come to control most of the discussions in our lives. But the exception rule still counts. The power belongs to the people except. And so when you look at the Bill of Rights, what you see, particularly in the First Amendment to the Constitution, are clauses that say, government shall not. I'm going to read it to you. If you look at my paper, I've hyphenated. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or, and this is the first subject we're going to discuss, abridging the freedom of speech or of the press. Congress shall make no law. What the founders intended to do is say to government, this is what you cannot do. Not what you can do, this is what you cannot do. Every case on free speech looks in terms of what government cannot do to infringe upon our individual rights in this nation to say what we want, when we want, about anything we want. That's the basic right. So, Why do I divide between public and private? Because those of you from public university systems are, guess what? An agency of the state. And those of you who run a private business called a private not-for-profit college are not agents of the state. You bottom line this, and here's the way it goes. Those of you in the public sector are obliged to enforce the First Amendment, which means you're obliged to stay out of people's lives, your students, your faculty, and your staff, on the subject of what they get to say, write, publish, wear T-shirts about, blog, or anything else, at least while on your campus or using your system. And those of you in the private sector have no such responsibility. None whatsoever. In other words, in the private sector, if you wish to say, hey folks, we are not going to criticize each other on this campus in a given manner, in the private sector, you get to do that. In the public sector, you do not. I'm oversimplifying, but you get the point. All right? So what I've done for you in the paper is give you the text of the First Amendment, tell you why I'm focused on it, and then I've divided it into subject matters. The first is employee speech. There are things employees in the public sector can and cannot do. Mostly, they can do almost anything in areas of speech. Recently, the Supreme Court said if your job as a public employee is to be an advisor on public issues to somebody else who's a public employee, you don't get the right to go public with your advice to your supervisor on a subject that is the subject of your employment. That's a nutshell definition of what's become to be known as Garcetti. So what you really are saying, for those of you who are public employees, you have to be careful when you decide you're going to go outside what we'll call the chain of command and just go public with your moral responsibility to say something to the public generally about what's going on in your institution. You can lose your job over that despite the First Amendment. There are some little safe harbors we'll talk about. Keep the word whistleblower in the back of your mind. When you go on to the next page, you'll see that I talk about student speech. Student speech in a public university system is a sacred cow. One is very, very careful about what one says to students they cannot say. And so it comes up on Confederate flags. It comes up with Nazi memorabilia. It comes up with racist speech. There are things that we as a society have universally agreed upon cannot be said despite the First Amendment, even in a public setting. We cannot incite each other to violence. The courts have said, we took that right away from everybody. You can't do it. The famous case also is, every law student learns this, baby. You cannot say fire in a crowded theater. By the way, all the lawyers in the room nodded their heads. The minute I went into that, everybody nodded their heads. That is drilled into us. We spend an hour discussing the fire in a theater case in law school. You cannot do that, all right? We've now gotten into other things. Through the agencies and through the bureaucracies, we've gotten into statutes that prohibit us from discriminating against each other. We're all familiar with that? Well, discrimination is the legal term. Harassment is the term that's used colloquially. Harassment is a colloquial term. It's a form of discrimination. Discrimination is illegal. You may not verbally harass people. You don't have a First Amendment right to do that. We as a society have taken that away from each other. And so I've labeled some of this stuff out for you. We don't allow, as a matter of our social norms, we don't allow people to engage in child pornography. Notice the distinction. We don't make that distinction about pornography generally. Frankly, the Supreme Court has said, under the free speech rubrics, we're not quite sure what pornography is. The famous quote of one of the justices was, "I'll know it when I see it." Every community has its own definition. But we as a society have said, child pornography is an exception. It's so dangerous, we are not going to allow it. It is not your free speech right to engage in child pornography. By the way, the take-home lesson for this is a little admonition you take back to everybody on your campus. Through various computer viruses, child pornography gets inserted into people's computers without them, frankly, being aware of it. You have to be really careful how you get that out of your system when it's in there, because in some states, when you're ready for the ultimate nightmare? You get a virus in your computer that has injected child pornography. You go to a computer specialist to take it out, and he's required to call it in to a social services agency. Trust me, you have never had a worse nightmare than that. You're into $100,000 before you get your name cleared. Just be careful of those things, okay? Notice I didn't tell you what you can do about it. Just be careful of those things. The catchphrase we use when we talk about writing handbooks and rules for students is that you have to have narrowly tailored rules. The courts will allow you to say, for the sake of public order, you can do this kind of speech in this part of the campus. So you can have a pots and pans salesman come to the student union. That person can come here. That person cannot display their wares in a residence hall. That's a famous case. Tinker? Something like that? Nodding. Good. Anyway, it's a tailoring of free speech, even on a public campus. So if you want to have a convocation of students, let's call it a protest. You want to have a protest of students. A campus can say, you can't do that in front of the hospital emergency room. We get to say that because public order requires that this be done in a certain way. Private colleges get to say, you can't do that on the campus. There will not be a protest on this campus. If you want to have a protest or you want to have a union picket line, you may do so on the sidewalk outside this campus. Now, case in point, I'm walking in this morning. There's a wonderful old fella, and I get to say old fella. There's a wonderful man on the intersection of the sidewalks handing out this poster. Who is the real biblical Jesus? Okay, he was a delightful guy. I stopped and I said to him, so, did you, knowing I'm going to be with you, so, did you have to get permission to do this? He said to me, well, you know, on private campuses you do, but people are pretty good about that. But on a public campus, you can do it as long as you're doing it within the public confines. That's interesting because, frankly, nobody knows whether the University of Vermont is public or private. It's a mixed bag. Cornell is a mixed bag. They have public programs, they have private programs. As I stand here, I don't know who owns the real estate, but obviously nobody's bothering him. He's out there distributing his poster. On my campus, you don't get to distribute Bibles on the campus. You get to stand on the sidewalk at the entrance to the main gate and pass out your little Bible, which nobody can read anyway because it's that big. But you get to do that. At the State University of New York, you get to do it pretty much anywhere you want as long as you're not blocking doors, et cetera, et cetera. That's the difference between public and private. That's what free speech is all about. Government cannot restrict that man. The state of Vermont cannot restrict that man from handing out his pamphlet. This is speech. This happens to be has religious overtones, but it's speech. On my campus, I get to say to him, this is my living room. I don't need you doing this. You can't do it. The next point of I've got expressive or symbolic conduct as the last item here, and I talk about in the paper what I just talked about verbally. So let's move on. The next point is the free exercise clause. By the way, those people who study the First Amendment divide it into clauses. That one, it's one sentence, and they divide it into clauses. The next section in the paper is called the Free Exercise Clause. I'm going to read you the Free Exercise Clause. It starts out again, Congress shall make no law respecting, here's the free exercise, respecting an establishment of religion or prohibiting the free exercise thereof. All right? Same sets of rules, only now we're talking about religious speech. So now we're talking about how does the University of Notre Dame offer a funded chapel on its campus that is just this side of a cathedral, and the University of Vermont cannot do that. And the reason is because once you invoke the Free Exercise Clause, you get into all of the rules of the Establishment Clause, and that essentially means public entities, Congress, and any derivative thereof, cannot establish a preference for any religion on any public property, Congress or any public agency. Not a private institution, just a public institution. Those of you who run public universities, we've already covered that. And so I've given you some of the cases that deal with that. Now, what pops up is this phenomenon all the time, and it is your employees' rights to practice their religion and not be infringed upon by you. And so we get into various sets of holidays. When does a person get time off to practice their religion? And when is that legitimate, and when is it made up? My favorite of these, by the way, is this one. And it hit, in a funny way, there's a meningitis outbreak. Have you followed that? Okay. You ready to, now, who's going to tie meningitis to my thing here today? Who's going to do that? If you've had to deal with this issue on behalf of a school, you will know that each of the states, with the possible exception of Louisiana, each of the states requires children to be vaccinated. All children. In New York, you cannot enter the school system at any level. If you come in as an infant, you're checked before you go to pre-K. If you come in any time after that, you're checked before you're allowed to enroll. You may not enroll in any school, public or private, unless you've been vaccinated. Why? It's a public health issue. What are the exceptions? A, the health of the child won't permit it. That's okay, has to be documented. B, the exercise of my religion forbids me to be vaccinated for anything. That's okay, but you have to prove it. Once again, Congress may not infringe upon the rights of the people to practice speech or to practice the religion of their choice, including the rules against vaccination, despite the risk to public health. Now, there are all kinds of rules of what happens when a person like that presents to the academic institution. The academic institution has to notify the county health department, has to notify the state health department, has to track that child, because while you have the right not to be vaccinated, you don't have the right to escape scrutiny. But the point being, government gets out of the way of people practicing their religion in almost every incident, including vaccination. Now, how does meningitis make its way back into our society? Interestingly enough, it comes in through people from other societies who come here and we don't know that they're not vaccinated. Or, worse yet, we have cults, and I use that word carefully, of American adults who believe that vaccination is injurious to their health. Those people are not immune from the vaccination statutes. They have not been held to establish a religious principle on which they can rely to escape vaccination. Because the only time government gets out of the way is when the Constitution says government must get out of the way. And the First Amendment has very clear rules: free speech and religion. Vaccination has been judged by the courts to not be a free speech issue, but it is a religious issue. And so you get to work around it only if you have religious principles, and you have to prove what they are. I had a guy, one of my, by the way, I got to put a plug in for this group before the day is out. I had a guy come to me on my home campus and say to me, I need Saturday mornings off. I need Saturday mornings off because my religion requires me to be doing something. I said, okay, so I looked at it. He is not Jewish. I looked at it and I said, well, explain to me this religious principle, and he explained it to me. And then I went on the internet. The internet is wonderful, huh? I went on the internet and I looked it all up, and of course there's no such principle. There is a religion, but there is no such principle. And then I looked at his time off and I noticed he was doing all kinds of interesting things on these Saturday mornings when he couldn't work, and all of them were related to the things he said he couldn't do according to his religious principles. I denied him the time. You know, you want to take Saturday mornings off, it's personal time off, and if you exceed your time limit, you look for another job. Them's the rules. In a public institution, I could have done the same thing, but I had to give him the benefit of the doubt that he in fact came to me with a genuine religious concern. He has that right in our society. You know, and I want to take a minute here and do a commercial. You all work with young people, okay? Once in a while, we adults need to exercise a little bit of pride of place. That's why I love to come to Vermont, Maine, Texas, North Carolina. They have real pride of place. We in New York do not understand pride of place, you know. As a matter of fact, our word would be forget about it. Pride of place is an American. The ability to stand here and have this discussion and talk about what we can do and what our government must not get in the way of, and then go out and practice that, is a uniquely American phenomenon in many ways. There's only a dozen countries in the world where you have the kind of unfettered speech rights that we have. Just look at some of the t-shirts you see on any given college campus and what they say. What they say is protected speech. That's unique to our country. You got to jealously guard that. You have to be careful of it forever. And most of all, you have to be really proud of it. You know, we're only 200 and some odd years old. It's an incredible phenomenon that we exercise and take for granted. All right, the next thing is freedom of association. Back to the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble. Peaceably to assemble. So you do have the right to set up a picket line. And you do have the right to protest. And you do have lots of other organized rights in our country that the government cannot interfere with. I lay out these rights for you, the right to unionize, among other things. Student unionization. How many of you work in institutions, you don't need to raise your hand, where you have graduate students? There is a nationwide effort to unionize graduate students. Now, some of you are paying them very well, and you don't treat them like interns and residents in a medical hospital. You don't work them to death. But the fact is, you like to have some control over what they do, and that's reason enough to give unions a hard time in the campaign process. But I want to suggest something to you. I said this earlier somewhere at this conference. The National Labor Relations Board is clearly on attack to challenge the rights of faculty and private colleges to unionize, in other words, to permit it. They are opening that can of worms again that we put to bed with a case called Yeshiva. I have that case cited for you. And they are clearly on a bent to allow graduate students to unionize. This is, we are currently living with a Democratic administration. These are the kinds of things that Democratic administrations do, and we're seeing it play out as we speak. And I share it with you, and I mention it to you in the paper here. Where it comes up in your handbooks, this freedom to associate, is student clubs. What clubs can you ban? What clubs must you allow? I lay out some of the examples here. So you have, for instance, some students want to organize a skydiving club. It's not particularly a speech issue. It's certainly not a religious issue. But guess what? It's a risk management issue. Most of us cannot insure skydiving clubs. Do you get to say to students, you cannot do that because I can't insure it? Yes, you do get to say that. And you get to say that even in a public setting. In a private setting, we're back to you get to do anything that's reasonable, but you do get to do it. Where it comes up most often in the public setting are religious clubs, the Christian groups, the various Christian groups, the Islamic groups, and now the Islamic groups in our society have subdivided into the Sunnis and the Shiites and others. And then you get into these political discussion groups, the differences between the Turks and the Greeks when they form a group that talks about Cyprus. And by the way, you want to have a field day, you want to sit in the middle of that discussion. But in the public setting, those of you from the public setting, you've got to find a way to express yourself such that you permit that kind of discussion. Where you have to be careful is cults, real cults. If you remember 15, 20 years ago, we were all on up all night, on razor's edge over the issue of cults because the cults were actively recruiting children on our campuses. And so we developed cult standards that the courts allowed us to enforce. They're very tricky because what the cults sought to do was hide behind the definition of a religious organization. I encourage you to get on the internet and look up the big public universities' treatment of cults on their campuses, and you'll find out how they delineated what is a cult and what is not a cult. Once you define a cult, you find a way to curtail its recruiting activities on your campus, usually under the public health rules or the orders for public health. Now, I'm on page 5, and there's this wonderful heading at the top of page 5 that says, private college or university. Those of you who are in the private sector, whether for-profit or not-for-profit, you should just applaud yourself. Okay? You have taken the easier road. In the words of Yogi Berra, you came to a fork in the road and you took it. Public is government, private is not. So the First Amendment rule about government not interfering does not apply to the privates. The courts will hold you to some level of reasonableness. We lawyers have an expression, bad cases make bad law. If you push a court beyond reasonableness, they will make a decision that you don't want. And in this day and age, when a court in the middle of Nebraska makes a decision that the rest of us don't want, every judge in America has access to it instantly, and it spreads like a virus. Don't go there. Be reasonable when you publish your rules. Be sensitive to the intellectual diversity you have on your campus. There are exceptions to that, of course. Those of you who come from very strong religious backgrounds and your campus is organized to promote that religious identity, you get the right to preserve that religious identity, and you should not give that up. You celebrate your privacy. By the way, as a lawyer who specializes in helping private colleges more than anyone else, you celebrate it. It is something you have a drink over. It is something you light birthday candles about because you get an easier row to hoe. But you don't get it if you don't use it. And so you come to a point in my paper that says this: whenever you're writing a policy, never, ever use the expression freedom of speech. Never, ever use the expression due process. Due process is a two-word phrase that appears in the 14th Amendment of the United States Constitution. It is absolutely binding on the states, all 50 of them. If you use that expression in your handbooks, when you're in front of a state court judge, the judge looks up the definition of due process. It's a public, legal, technical term. So if you have, for instance, a hearing process from which you exclude lawyers in your handbook, and those of you, by the way, those of you in the public sector, you can weep over this. Private college disciplinarians do not need to have lawyers in the room. Think about that little gem. I tell my clients, under no circumstances do you have a lawyer in the room. Occasionally, when there's a really, I make exceptions to that. If the kid is being charged with a crime simultaneously out of the same set of facts that the kid is being disciplined for in your system, I allow the lawyer in the room and don't allow the lawyer to participate in the hearing. The reason I want the lawyer in the room is to tell the kid to shut up, because anything in our transcript is subpoenaable by the district attorney. It's not privileged under any under any imaginary rule, and so anything the kid says, the DA gets to use against that kid in the subsequent criminal trial. Our hearings will, in our world, our hearings will always go before, in time, the criminal trial. And so I allow the lawyer in the room to protect his client or her client from saying anything that's incriminating. Other than that, there are no lawyers in the room. I'm not in the room. The college does not have a lawyer in the room. Let the administrators and the students work it out. By the way, they're very good at it. They'll work it out. They'll use a fair and reasonable set of terms, which is all the courts require of those of you in the private sector. When you're writing your handbooks, you're going to provide hearings that are fair and reasonable. The courts have defined that to be, you're going to give the kid notice of what they're being accused of. You're going to give the kid a hearing, a right to present witnesses, a right to cross-examine the witnesses. You're going to give the kid a right to an appeal. That's pretty much it. Did you ever see the word lawyer in any of that? That's because the courts have not said you need a lawyer in any of that. On the public setting, on the other hand, you insert lawyer all along the way because the publics are required to abide by the rules of due process. The point of all of this is, as you're writing handbooks and you're in the private sector, and we're on the section of my paper that deals with private sector, you never, ever, ever use the word due process. By the way, the price of tuition is paid for all of you in this room. If you go back to your campus, pull up all your rules, punch in a search engine for the words due process, and whenever they appear, you delete them. You've paid your tuition bill, okay? Same true with freedom of speech. When people come into your living room at your home, do they have freedom of speech? Anybody? Absolutely not. If they come in and start slandering someone, if they come in and start using vulgar language, if they come in and start being volatile, you tell them to leave. It's your home. The private campus setting is designed under the law exactly that way. It is a private living room. You get to make up the rules. You have to be careful about what you're willing to live with on this. You don't publish really prohibitive speech rules because they're going to appear on the front page of your local newspaper. And for market purposes, if no other, you don't want that. You don't want to be known as a campus that infringes upon speech rights. Are there exceptions to my advice to you on that? Yes. Religious colleges that have strong religious foundations tend to limit speech. People who go to those colleges go there knowing that those are the rules. So they're not surprised when it's in a handbook. That's okay. The rest of you, like a place like mine, Rensselaer Polytechnic Institute, the oldest technology-oriented school in the English-speaking world. We are non-sectarian. We have a long tradition of harboring people of Jewish faith who couldn't get into the Ivies. Long tradition of that. We have a long tradition of international students, and so we have Islamic students, we have Hindu students, and we have students whose religions we never heard of before. Long tradition of that. We stay out of the business of regulating that kind of behavior as long as it's orderly. Speech is not regulated on my campus as long as it's orderly. We have a computer civility policy. We tell students in the course of using our computer system, we own the servers. We tell students, we publish a set of rules. You can look them up on my website, by the way. We publish a set of rules. Here's what's expected of you when you use our system. And by the way, if you don't follow these rules of civility towards each other, you're going to be cut off from the system. I get to do that. The publics have trouble with that. I get to do that. I get to say to the faculty, you cannot slander each other on our server. I get to do that. They don't have another server they can use, and they complain about it. I'm sorry. Let's not mix up. As a matter of fact, I saved the paper. There's a wonderful paper here on academic freedom that was done by Kathy Westcott. Let's not mix up what you get to say in a classroom with what you don't get to say outside of the classroom. Let's not mix it up. You don't get to slander people. You don't get to say all those mean things on our server. And you don't get to do it because we said you don't get to do it. We're private. It's our living room. We get to make up the rules. The we, by the way, is the trustees, if you think about it. So I covered the due process and I covered freedom of speech, and I want to leave time for questions and answers. Fraud and misrepresentation. No one protects any of us from fraud and misrepresentation. If you print it up or you talk about it that way, whether you're private or public, there are other statutory remedies available to people, and you don't get to hide behind the phenomenon of you get to say what you want to say whenever you want to say it. It's simply not true. What you're seeing going on right now in the law schools of today is a phenomenon of the law schools are trying to prove that everybody gets a job. That's an absolute myth, all right? And those of you who counsel students that are thinking of going to law schools, please counsel them about the economics of the practice of law. It's an absolute myth. So what was going on, some of the law schools were hiring unemployed graduates to work at the law school. Okay, think about that. All right, so you're going to run the copy machine, you're going to sweep the floors, you're going to work in the kitchen, but you're employed statistically. That's fraud. All right, and sure enough, somebody went after my august profession on that ground alone. You don't get protection from that under free speech. I've covered earlier in my discussion employee speech. The National Labor Relations Board under the National Labor Relations Act protects employees, both public and private, from certain types of behavioral control. You want to keep an eye on that. And then the final thing I want to mention to all of you, what time do I wrap up here? Anybody know? Say it again. 10:45. Okay, we're doing 10:45. Boy, am I out of gas early. Okay. What I wanted to share with you was we've taken speech and given it a funny coloration. The Constitution says that our government may not infringe upon our rights to speech. What we're beginning to see is our government mandating speech, which is an interesting flip side of the coin, all right? Now, there are parts of this that you're very familiar with. If you go into a medical facility with a gunshot wound or a knife wound, they must report it. Some places require reporting of dog bites. It's a public health, public safety override of the freedom of speech. What you're starting to see now is out of every bad set of facts or bad case law comes another speech issue. So what I'm starting to see now is Congress talking about imposing on colleges and university athletic departments certain types of child abuse. Well, you know, I understand the legislative concern. I don't know why you now, actually we all do know why you're looking at college athletic departments, but it's really kind of silly. What I want you to think about is as you go up to 30,000 feet, this is government treading in heady waters, because what the founders thought about was telling us as a society where Congress could not interfere in abridging our speech. They really didn't think in terms of Congress mandating our speech. But we're starting to go in that direction, and I encourage all of you to think about what that really means. Now, here's a particular speech area that I want to share with you that people don't usually talk about in this context. The various civil rights statutes, and by the way, let me back up. You ought to have on your campus, because your 990 has a box that says, do you have a whistleblower statute, a whistleblower policy on your campus? You ought to have a whistleblower policy on your campus just so you can check off the box. I don't know why the IRS feels it necessary to ask you that question. It has nothing to do with anything, but it's there. Do you have a records retention policy? It's on the 990. Do you have a whistleblower policy? Do yourself a favor and put some policies on your books so that you can check those off. Don't leave it to the editor of the New York Times to ask you why you don't have a whistleblower policy or a records retention policy. Records retention policy really works like this. It isn't about how long you keep your records. It's about whether your community knows once records have been requested by a public official, you can't shred them. That's what a records retention policy is really all about. And it comes out of the famous Arthur Anderson shredding incident in Houston, all right? Because our government is very good about using nuclear cannons to kill insects. And so we have that kind of legislation running around. The other one is the whistleblower thing. Whistleblower policies are attached, whistleblower sections are attached to a lot of the non-discrimination phenomenon. Now, the reason that they're really there is to prevent retaliation. And I'm going to take you through this by the numbers. Somebody says, As a matter of fact, for those of you who came to the earlier session on the Free Report, there was a statement in the Free Report where the janitors at Penn State saw actual child abuse by Jerry Sandusky and didn't turn it in because they were afraid they would lose their jobs. That's the premise on which all of this is built. How do you give people an avenue to bring something to the attention of policymakers without losing their jobs? And so we invent these whistleblower phenomenon and we attach them to statutes. And what they say is this: anyone who sees something and reports it cannot be retaliated against. So you can't not give them a raise, you can't transfer them, you can't fire them, you can't give them a bad letter of recommendation. It's the retaliation that's the target of the statute. Do yourself a favor and have a whistleblower policy. But here's the interesting thing about it. It's an infringement on speech. The whistleblower is called upon to make a speech and then given a harbor of protection after the whistleblower makes the speech. The speech being, I saw the vice president for administration in inappropriate behavior with a female that works for him. That's the speech. And the minute I make that speech, you can't fire me for that. You can't deny me a raise. You can't transfer me. You have to protect me. Ladies and gentlemen, that's the law. All right? The problem you run into is when the guy who makes the call is himself a misfit. He has now taken his own behavior and taken it out of circulation by putting himself in a safe harbor where you can't go after him. That's the problem. Happens every day, by the way. You're lucky when the person who makes the complaint is in fact somebody that is not on some other list in your HR office. But as often as not, the people find this as a way of getting even. I'll show you. I'm sending in a written notice that says this. In some states, to get whistleblower protection, you have to actually be reporting a crime. In some areas, to be a sheltered whistleblower, you have to actually be reporting something that is at least illegal, unethical, or immoral, whatever that means. Unethical or immoral. That's one of those things like pornography. I know it when I see it. Illegal is easy. It's statutory. The problem is always the guy who's trouble to begin with and puts himself in a corner that is protected by the statute, and now you can't deal with that person. Do yourself a favor and look at the whistleblower stuff on your campus. If you don't have it, give yourself something. I'm out of gas. Who's got questions? On anything. By the way, we have enough time, and I've been doing this. Steve and I were talking. We've been doing this longer than we're sharing with any of you. That's how long we've been doing this. Let's open this up to any question on any subject, because we have a good 15 minutes, and I owe you that.
Yeah, you raised the point of, I'm a public university, you have been my entire
Condolences.
Thank you. You raised the point about you can control the speech that goes out over the university servers in a private setting, and that in a public setting, we have more difficulty. It sounded a little equivocal there. Is the basis of your analysis that the public, or that the servers that are owned by the public entity are the equivalent of the grounds of the university? Are they equivalent of an area that would otherwise be open to free speech?
Yes. And that, you know, when you're looking at free speech, the safest way to do it is to not try to invent, is to go backwards, all right? And the easiest way for people our age to think is in terms of printed documents. A server is a printed document. It's just a little different. The internet is... yeah, okay, I'll take that. But the message that comes out is a document. What I'm really saying to you is don't try to make it more complicated. It's not. Stay with the basic rules you understand, and believe it or not, you just did it. Believe it or not, it makes sense when you stay with the basic rules. The server is the property of the university, and therefore the rights that attach to any public property attached to the use of the server. You had it. You're right on the money, okay? And the email message is a newspaper in a public setting. It's any other public document. You have to be really careful in the public arena when you're dealing with First Amendment issues. But you don't have to invent new rules because I make a point in here. Those of you in the public setting, you are the publisher of your student newspaper. You don't get to tell the kids what to write in that newspaper. But you have an obligation to encourage them, to mentor them, to have some professional ethical standards about what the role of a publisher is. And in this day and age, that works, okay? I put in your example, how do you keep your kids from publishing the Kate Middleton photos? Now, interestingly enough, the American press elected not to do that. The European press did whatever they wanted. It's a question of publishing standards. It's not a question of rights. The American press could have published those anytime they wanted to. Now, when we're working with students, it's up to us at our position in their lives to teach them how to do it and in the public setting without demanding it. Now, at RPI, we are let me say I, and my president's not here, I get to say I. I'm the publisher of the student newspaper. I put together a media statement patterned after the First Amendment that keeps government out of the way of the editors of the paper. But the government that they insisted being out of their way was the student union government, who in fact funds them. Like this operation, it's all funded by the students. I don't fund it. I'm the licensed publisher. They fund it themselves. And what they were worried about is how do they keep the people giving them money out of their knickers in what they publish. And so they developed a kind of First Amendment thing that I did for them 100 years ago that is focused on their government staying out of their way. Does this all make sense?
Charles, finally, just interject. I spent 33 years in public institutions too, so I saw the right side, went to private. But, excuse me. And Charles is of course right when he says the internet is just simply another piece of property. That doesn't mean you can't punish people for abusing the use of your property. Anybody from Virginia? Okay, there's a great case out of Virginia called Urofsky versus Gilmore, where the state legislature passed a law that said no public employee may use state computers to access pornography, to make it simple. And of course, the faculty students said, well, I always do my research on pornography, so you're affecting my academic freedom. And it went all the way up. The board said, no, faculty member is just another state employee, and we can restrict the use of state computers for the janitor and for the full professor as well. There's a lot more to that story. But in fact, your institution can deal with misuse of computers, use of pornography, the transmittal of threatening messages, even if you don't have civility policies. So it's not quite as free as perhaps you might think about it. And you certainly can regulate it. And the biggest regulation is everything that shows up in the university computer from a public institution accessible by public disclosure law. So by simply telling faculty or your staff, gee, if you write it, you might as well publish it, usually has enough sense of limitation for most normal people who don't want their email to be on the front page of the newspaper.
That's correct. You know, and you trigger something in me also, since we have a little time. And those of you who need to leave, please feel free to do so. You know, when we got ourselves into the cautionary mode after 9/11, our government passed something called the Patriot Act. Patriot Act gives government a serious right to infringe upon your freedom of expression and freedom of speech, public or private. And they do it without a court's oversight, and they do it by subpoena. And so, for those of you who haven't experienced this yet, If you get one of your students engaging in activity on your servers, public or private, that comes to the attention of the FBI, they will come and extract that material from your server, public or private. But you really had the best analogy when you talked in terms of property. Okay? Who has something? Somebody here had a question. You did.
To follow up on the whistleblower issue, obviously if someone makes a statement that's untrue, as you've outlined, there's a way to follow up on that. But let's just say for hypothetical purposes, someone does in fact observe an impropriety or whatever, and they are on the HR list for something totally unrelated, do they become totally protected in their employment just because they did in fact whistleblow on something that was covered? You have no recourse.
The answer is, I'm a lawyer, I get to do this, okay? The answer is yes and no. Because here's what, in fact, let's start with the technical answer. Of course they don't get any additional protection. Of course they're still responsible for the behavior that's on the HR list, all right? That's the no. Now here's the yes. How do you enforce that? The minute you go after this person, they go to, you file a discrimination complaint in our society all by yourself. You don't need any attorneys. You go down, you sign your name to a piece of paper, and it's in. And at that point, the Office of Civil Rights or your local state agency, whatever one is responsible for this, is on your doorstep, and you're guilty until proven innocent in this set of circles if you're an entity, is on your doorstep saying, explain yourself. Why are you retaliating against this individual when in fact they were a whistleblower? And your answer is, I'm not retaliating against them at all, dealing with a prior complaint that I just hadn't gotten around to. Now you come to the point where if you take this and run it out to its logical conclusion, the Office of Civil Rights gives the person a right to sue letter. Maybe they find harassment or discrimination, maybe they don't, but they give the person a right to sue letter, and now you're defending yourself in front of a jury. It's not where you want to be. First of all, you're $50,000 minimum legal fees into this already. So the practical answer is, once they engage in a whistleblower statute, you're stuck. I'm sorry to say that to you, and I know it from personal experience because I'm stuck a lot. And I want to add something to this, but I've forgotten it. So you asked your question, and I'll bring it back.
Are you suggesting, for college policy purposes, a whistleblower that you could mandate employees to whistleblow? In other words,
No.
if you do not recruit.
No, I'm not. By the way, there are people, that's called an honor code. People are talking about going in that direction. I have real problems with honor codes on anything, at the student level and at the and the problem I have is statistically, the evidence suggests they don't work. That's why I have problems with them. Where they do work, in fairness, I'm back to these very strong, well-organized and well-run religious institutions. Honor codes work, and they work well. But when you get out of that milieu, those are tough. And so I know the point I was going to make. Every state has its own whistleblower rules. Some states require that in order for the whistleblower to engage in protection, get the protection, the conduct has to have been illegal. The conduct has to have been a matter of illegality under the law. And some states just require, and that's not fair if you think about it. Some states require that there has to be just a reasonableness to the activity that is the subject of the whistleblower's complaint. In other words, the whistleblower had reason to believe unethical or immoral or illegal activity was occurring. And once they report that, an objective person looking at it can give them the protection of the statute. You need to know what your state's whistleblower standards are. Every state has different standards. Other questions? Go ahead.
You're saying that somebody got an objective look at that, is that like typically one person, or is that a committee of us, that aspect to give them protection?
Well, ultimately it's a jury. And so you've got to have people on your campus who, I hate to say this to you folks, because my bias is towards the small privates, this is where lawyers earn their money. Okay, good lawyers in the academic setting know what you can get away with and what you can't. But absent the lawyers, honest to God, Google is your best friend. You can actually look it up. Punch in whistleblower. Punch in somebody's issue. Punch in your state's. Punch in whistleblower, New York. Up will come the state statutes. Punch in whistleblower, Harvard. Up will come that university's rules for this kind of thing. Do yourself a favor and write your stuff that way. This is about handbooks, after all. Write your stuff that way. If you're really in trouble with a particular paragraph you want help with, there are organizations like, I told you I'd get to this, the ASCA. You know, they train your staff how to look for these kinds of issues. It's very good. It's dirt cheap. This one's under $100 a year to belong to. I'm one of the people that helped start it. Steve, were you involved in that movement also? One of the people that helped start it. It's a wonderful organization focused on student life and focused solely on the student discipline arena. A great thing. But there are lots of organizations like this that have the unique focus, and they have these rules and pamphlets in place. You can get them without inventing this stuff from the ground up. And I encourage you to do that. It's too complicated to invent from the ground up. And the final thing for small colleges, there are lawyers in private practice who engage as general counsel for several different university systems. I used to be one. They're less expensive because they have many clients, and they're fast because you're not going to ask them something, as often as not, you're not going to ask them something they haven't heard before. If they've been at it a while, they've heard it all. You're just going to get an answer a little more quickly because they've been at it. So you can get what a big university system gets for less money and without hiring a full-time lawyer. Other question?
You know, when you get in these situations where you have a guy that thinks he's a whistleblower, and makes an allegation that's not true, and he does file, and he's protected. Eventually you come to financial decision. What's it worth to get rid of that?
Absolutely. You're absolutely right.
You write a check if you want to get rid of that person.
The point made was, even when you have somebody in a safe harbor under a whistleblower statute, sometimes if they are a troublemaker, legitimately, not whistleblower, but a legitimate troublemaker, you make up your mind that you're going to bite the economic bullet and you're going to deal with the person and pay pay the legal fees to get rid of this person. And that's absolutely correct. You have to do that occasionally. There was another, you had a question.
This has to do with what I would call the expectation of right to privacy in the classroom. On a public campus, apparently I lost my keys because I used to work at a private school, now I work at a public school in New York. This was a case in which in the classroom building, there was a community program that had brought high school students, and they were in the same building as academic classes going on. The community program had hired a photographer to take pictures of this program. It was a lovely program. The photographer accidentally went into a classroom with a camera and didn't actually take any pictures, but the faculty member in that classroom got very upset that the right to privacy of the classroom had been violated, and that this person was going to violate the students' rights by taking pictures of them, and was violating the students' right to free speech because they came in when a student was talking.
Okay, now for the benefit of the camera and Eric, who's back there falling asleep, the question is, what happens when a camera person inadvertently goes into the wrong room and starts photographing students and faculty delivering a class that has nothing to do with the reason the camera person was hired? Is that a good synopsis? All right. Let's start with a basic premise. The Constitution of the United States does not give anyone a right to privacy. It's a myth. We talk about it a lot. The Supreme Court is asked to find it somewhere. It's a problematical thing because remember what we said about the Constitution. The Constitution is designed to keep government out of our lives. It's not designed to create new rights for us. And so the right to privacy is a very difficult thing to find. the difficulty that we have is faculty in our lives have, this may be a uniquely American concept, have invented a notion they call academic freedom. And they often overlay academic freedom on some other governmental issue, and out comes a hybrid that they think is real. It is not. What you have at best there is a commercial issue. People have a right not to be photographed and then have the photograph used commercially. In our society, people don't really have the right not to be photographed. My iPhone is, look at Prince, whatever his name is. Who's the prince? Harry, thank you. I'm sorry to get that graphic with y'all, but people don't have a right not to be photographed anymore in ours, if they ever did in our society. But you do have the right. If you notice on television, you'll see a police film where the characters in the police film, other than the cop, have their faces blurred out. That's a commercial issue. That's not a right to privacy. If you're going to use something commercially, you have to have the consent of the people who are actors in your movie, whether you pay them or not. Does that help? Now, what do you do about it would be your next question. What do I do about it? Well, the fact is, you get the faculty member to get a grip, okay? All right, and if you've accomplished that, you've done it all. I don't need to tell you to do it. There are no rights that I can see being violated there unless on your campus you have somehow given each faculty member an inviolate right to the control of who enters and exits that classroom during their presentation. And by the way, if you've done that, please find a way to take it back, okay? You're seeing this played out in a funny way in the Chicago Teachers Union strike. What was the central issue in that? Central issue was evaluation of teachers. And the technique that's trying to be used in the secondary school system is a technique we use in higher ed, at least we're supposed to, where the dean walks into a classroom and sits and listens to a presentation. Okay? I wish we actually did what we say we're doing. We, as often as not, do not. Well, they're trying to evaluate secondary school teachers in that manner, and the secondary school teacher, and other manners, and the secondary school teachers are protesting.
I might just add that in that situation, it's not uncommon for faculty to say, you're not registered for my class. You didn't pay to come listen to me. You have no right to be here. You could argue that that faculty member could have said, Doctor, I'm sorry, you're not a registered student. If you want to register, you can come to my class. And so in a way, we have given our faculty the right to say who should be there.
That's correct. Stephen's right, but he's a lawyer, so we get to play lawyer, okay? What he really said just then was the faculty member gets to enforce the university's right as to who's in that classroom. See, and that's an interesting distinction. Unless you want a fist fight, you never make that point with a faculty member. They don't control the grades. The university is responsible for controlling the grade. That's why when a student appeals a grade, somebody else makes the decision, not the faculty member. They don't control who's in the classroom and who's not. The university does. They are, for purposes of Stephen's example, the agent of the university who gets to enforce the university's rights. If you're going to make that argument, you do so at a distance with a shield in front of you. But that is, in fact, the way it works. Who else?
Going back, I'm from a small private university in Maine, and going back to your comment on if you're private, celebrate it, we pretty much run with the assumption that we should be as much like a public university as we can.
That's okay, as long as you see, the wonderful thing about, the statement was, she's from a small private who celebrates the fact that they operate like a public, and so they use those standards. I'm okay with that as long as you understand what you've given up. If you make that decision, that's a decision. My problem is people make those decisions without knowing they're doing it. Some young person in the dean of students' office writes a handbook that says, we have due process. Hold the fort, Nellie. Did you really mean that? If you mean it, God bless you. Okay? Some publics, and I mentioned this in the paper, some publics don't limit themselves to the constitutional rights. They extend beyond that. They give their students additional rights. That's okay. My point with all of you as professionals is, know what you're doing. Say what you mean and mean what you say. You can write that down if you want.
So I understand at a public institution you have the right to limit time, place, and manner of, I don't know, protest or speech or whatever.
Right.
Do you get in trouble if you limit certain groups differently?
Oh, I couldn't have paid him for that. The question was, he understands that in public universities you have time, place, and manner constraints that you can put on speech under the interpretation of the Constitution. And then he says, can you do that differently for different groups? And the answer is, for the most purposes, no. Okay? There's always exceptions to that, but boy, be real careful with that one. People, be real careful with that one.
What if one of the groups you thought might incite a riot? You have no proof of this, but it just might, so you want to treat that group just a little bit.
Okay, we're not going to let the Hells Angels organize. By the way, the Hells Angels in my neighborhood are all over 60 years old. Okay, and they ride antique Harleys. So we're not going to let the Hells Angels do what we would let the YMCA do. You're not going to get away with that. On the other hand, if last week the Hells Angels were on his campus and you had this kind of an issue, you do get to impose different security measures based on experience that is documentable. Okay? You don't have to wait for the riot. You get to act based on, if the KKK is going to appear on your campus and you have a large minority population, you get to look at what happens historically in other neighborhoods when the KKK shows up on a public campus, and you get to react accordingly. The answer is yes. You notice I gave him a no answer and then a yes answer. You all got that? All right, good. Eric, did you get that? Okay.
Years ago, we had a Christian group come in that was at a conference for against the LGBT community, specifically around anti-gay marriage. And so the university could not stop them from coming in and using the data center. But what they did was encourage the LGBT community to have their own event. So they gave Pride back at the same time. So the whole messages were being presented, but no one was being restricted from expressing themselves.
Okay, now for the television, we're talking about an event that occurred on the Davis Center where a religious affiliated group came in and wanted to put on a program, the theme of which was anti-gay marriage, and the university's reaction was to allow that, but to encourage a group with opposing sympathies to have a demonstration at the same time. And the only issue there is how much public safety you're going to pay overtime to while you do all of that. And we're back to something I said to all of you twice during this conference. Don't let people cut your public safety budgets. Your campus police, well-disciplined and well-trained, is your first line of defense, followed quickly by your resident assistants. All right? Am I now out of time? I am. Ladies and gentlemen, thank you. I appreciate it.